Hello there, Jim Miskell from the Estate Planning Law Group of Georgia. I wanted to talk today about a topic that we cover really frequently with clients as we're discovering with them which kind of plan is going to work for them. And a lot of times folks say, well, do I need to do a trust? And the answer on that is usually no, you don't need to do a trust. There are features of living trusts that provide advantages to families that may be the right fit for your family, uh, may not. Um, a lot of folks get the idea that wills don't work; they're no good. Um, it's not true. Wills will work. Um, the difference between wills and living trusts 2 years after somebody dies, you wouldn't be able to tell which was it that they had. The distributions to um, beneficiaries, whether they're kids or somebody else, can be in trust or outright distributions. They could be exactly the same, whether you use a will plan or whether you use a living trust as the basic, the underpinnings of your plan. The difference in getting to that endpoint 2 years from the death of somebody is the road that's traveled, the path that the family has to travel to get there. With a will, you're going through probate court. One of the things we talk about a lot, um, clients and I, when we're having conversations, is that powers of attorney work very well to designate an agent while you're alive, but they stop working as soon as you die. So to give somebody the authority to transfer property out of your name after you die, that's where the probate court comes in a will situation. And that's where going through the probate system, filing the will, notifying all the heirs at least 30 to 45 days before the court provides the letters testamentary. And the letters testamentary is the order from the court that in many ways is a substitute or a replacement for that power of attorney. It allows your agent to go ahead and do the things that need to be done, change the title of the house or sell the house, move property out of your name into somebody else's. Wills work. And in Georgia, the probate system is less onerous than in a lot of states. So we've got a pretty favorable situation in Georgia. Costs for probate somewhere, once you pay filing and publication fees, you might be $300 to $500 in. When you hire an attorney to help through that process, I tell folks to think about budgeting for probates $2,000 to $3,000 per probate. Legal fees generally going to be somewhere between $1,500 and $2,500. So very often, once you think about two probates for a couple, the cost of doing a living trust now makes a lot more financial sense. That money isn't needed to be spent later. And wills plus probate, usually the cost is higher than doing the revocable living trust now. Another advantage of the living trust, of course, is that you get to do the administration now the way you like it and make sure all your ducks are in a row. You can take some pressure off the family in times of grief and crisis. I met with a family last week, went through all the discussions about what was important to them and in their distributions and the administration of things. And the will plan made the most sense for them. So wills will work. They happen to have somebody that a family member who has done probates for other family members before, works in a lawyer's office. They thought it was going to be very easy, and it also was going to minimize their cost for probate later. So in their situation, because the family structure was very simple, because their distribution plan was very straightforward and very similar to what intestacy is in Georgia. That is very similar to what would happen if the wills turned out not to be any good. The advantages for a living trust didn't make sense to them. It was actually more cost effective to do that will plan. So wills will work. The big difference is you're asking your agents to go through extra administrative steps later, a path that takes them through the courthouse. Living trusts for a lot of families just simply make more sense, not only from the ease of administration for the family, but actually cost in the long run. So that's it. Wills will work for a lot of families. Living trusts are the better plan. The Estate Planning Law Group of Georgia, all centered around an educational process and making sure that your planning meets your needs, that we don't have a preconceived idea of what plan you should have before you come in. It's really determined by the conversations we have. I don't have an idea what will work best for your family. I've learned over the years that clients know better what's important to them than I do, and that listening to them gets the best result in the end. I'm Jim Miskell with the Estate Planning Law Group of Georgia. I hope that we can talk about your estate planning soon, and have a great day.